This is LXBN TV, and I'm Colin O'Keefe. Non-compete agreements in California are automatically void as a matter of law, except for a few specific circumstances. That includes the sale of a business. However, a recent decision by the California Court of Appeals says they might be void even then. To explain, we bring in Joshua Salinas, attorney in Seyfarth Shaw's Los Angeles office and author on their blog, Trading Secrets. Joshua, first off, can you give us some background on the case and why the court ruled the way it did?
Yes, as you had mentioned, California has a general prohibition against non-compete, except when there's a limited exception when it's pursuant to the sale of a business. And that was at issue in this case. You had a employee of a video game publisher named Michael Moss, who, when his company was ultimately acquired by another company, he sold his stock, his shares in that business, and executed a stock purchase agreement when he sold his stock. In that purchase agreement, it had a 3-year general non-compete where he wouldn't conduct any competitive business, participate in any distribution or litigation of video games. But also in that stock purchase agreement, he also agreed that he would continue to work for the company for 3 years and execute an employment agreement. Now, the kind of key fact in this case was that employment agreement had a separate and different non-compete than the stock purchase agreement. In his stock purchase agreement, it was a general 3-year non-compete, but his employment contract had a non-compete that he wouldn't compete for an additional 1 year after the termination of his employment or the expiration of his contract. And so the dispute arose when Mr. Moss left the company to join a competitor, and it was actually 3 years to the date he signed that stock purchase agreement. He left, believing that he had satisfied that 3-year non-compete, and he left for a competitor that was called Solutions to Go. Now, the plaintiff in this case, Phil Point, was a video game distributor, subsequently acquired the business assets and the contract rights to Mr. Moss's former employers, and what it did is that it sued him for breaching that non-compete agreement. It said that, it had this additional 1-year post-termination agreement, and because he left for the competitor, he was violating that agreement. And it also sued Solutions to Go, his new employer, for tortious interference, saying it was also interfering with that, that contract agreement they had with Mr. Moss. And so the case went through litigation, and the defendants moved for non-suit, saying that, as a matter of law, the non-compete in the employment agreement was unenforceable. California has its general prohibition against non-compete, and while there's that exception for the sale of a business, that applied to that 3-year stock purchase agreement, and the company, received that 3 years. Mr. Moss worked for 3 years, and then he left, and therefore all that was left was this 1-year employment contract that was really separate and did not apply under that exception. And so the trial court did find in the defendant's favor, saying, these are 2 separate agreements, 2 separate non-competes. The 3-year applies to the purchase stock agreement applies to the sale of a business. That applies under the California's limited exception, but the separate employment contract that does not apply, and therefore is going to be void and unenforceable under California law. So Phil Point appealed, saying, the trial court, they got this all wrong. Both agreements were executed pursuant to the sale of the same business, same single transaction. Both agreements actually cross-referenced each other. They're between the same parties. And in fact, the employment contract was even attached as an exhibit to the stock purchase agreement. So it was saying, you have to look at these both together, and because the employment contract was really executed pursuant to the sale of a business, it should kind of be incorporated and fall under this sale of a business exception. And the Court of Appeal, while it did agree with Phil Point's view, it did say that, they are part of the same single transaction. We are going to look at these 2 agreements together. It still did not find in Phil Point's favor and found that the agreement under the employment contract was still unenforceable under California law. And the reason behind this was the court said that the sale of a business exception, the purpose is to protect the business's goodwill. Employment contract, really did not protect the business's goodwill. It was, focusing separately and targeting Mr. Moss's right to employment, to pursue his profession, to pursue his career. So what the court did is, even though it looked at both agreements together, it said, they have two different purposes, and therefore we're not going to automatically view the employment agreement as falling under the sale of business exception, and therefore found it unenforceable under California law.
And second, what are the takeaways for businesses? Is this a really unique circumstance, or are there some takeaways that other companies can learn from this?
It's a unique circumstance to the extent where the non-compete that was in the stock purchase agreement was different from the non-compete in the employment agreement. So it may kind of upset some well-settled expectations for employees or employers or companies who have contracts that are similar, that are in two different agreements that are actually different non-competes. But what the ultimate takeaway from this is that if a court is going to look at these two agreements together, it's not going to automatically assume that the employment contract that is executed pursuant to the sale of a business is necessarily going to also fall under the sale of business exception or California law. And the court really wants to, see that the clear purpose behind any non-compete in the agreement is to protect the business's goodwill. It's a really kind of significant case because companies want to have, some recourse and be aware of the risks. When you have these non-compete agreements, you have companies who sometimes pay millions to an individual to acquire their business interests, and to have the individual, that employee, later turn around and start competing, it can reduce the goodwill or that value of the business that was recently acquired. But the significant thing that companies can take away from this is to really kind of be aware of the risk that courts are not necessarily going to construe all the contracts, all the agreements necessarily in your favor. There really has to be a clear, obvious purpose that it's for the goodwill. And so kind of going forward, companies should have that clear purpose of protecting goodwill of the business in these non-competes to make sure it falls under the limited business exception.
I see. Well, again, that was Joshua Salinas of Seyfarth Shaw and their blog, Trading Secrets. For more of his insight, be sure to visit TradeSecretsLaw.com and curated commentary from the LexBlog Network's thousands of authors. Come visit us at lxbn.lexblog.com. Thanks, Josh.
Thank you.